This case isn't just about sentencing. It's about credibility, accountability, and a decades-long collision with the justice system. A Michigan man is back in court after the Court of Appeals sends his sentence back for review. But instead of relief, things may actually get worse. Allegations of force against police, disputed facts, a history of repeat offenses, and a judge who's clearly not convinced. The question is, did the system fail him, or has he failed every chance the system gave him? Let's break this courtroom moment down step by step.
And we're here for a resentencing on remand from the Michigan Court of Appeals in the case of People versus Marty Mitchell. It's filed 22-6430. Counsel, you want to state your appearances for the record, beginning with People?
Melissa Goodrich, Wayne County Prosecutor.
Good afternoon, Your Honor. Melissa Krauskopf on behalf of Mr. Mitchell. He's present here, seated to my right.
Okay, the advisory guidelines have been scored at 12 to 24 months. Ms. Krauskopf, any scoring challenges from the defense?
No, Your Honor. I believe 12 to 24 months is accurate.
So People did file an objection to OB-19 being scored at 10 points, arguing that it should be at 15 points. Ms. Goodrich, are you continuing that objection today?
Yes, Your Honor. Your Honor, due to the amount of force that the defendant used that day, he had driven off beyond the officer's commands, and then so they had to pull him over again, and then he refused to get out of the vehicle, rolled down the windows. They had to break through a window and then pull him away from the steering wheel. He began kicking the officers with his legs. Therefore, we believe that OB-19 is properly scored at 15 rather than 10 points.
That variable, OB-19 was scored at 10 points on the original sentence in this case. When asked if there were any additions, deletions, or corrections to the guidelines of the original sentencing, the People said no, so there was no objection made at the original sentence. Following the appeal in this case, the People did file a confession of error. The COA rejected it because we didn't quite agree on the remedy, although we agreed that there was an error. I appreciate that a resentencing opens things back up, but I will, I guess, just put on the record that I don't love the idea of that variable being scored now when the People had an opportunity to correct it previously. It feels a little punitive.
A remand for resentencing does reopen all issues for resentencing, and I've seen sometimes where then the defense has objections that they didn't have previously. As long as, I guess, if it had been presented and argued in the Court of Appeals and there was an adjudication on the issue, it of course would be law of the case, and we wouldn't be able to reopen it even if they're, like if they hold that something was improperly scored and they send it back for resentencing, we can't just, that scoring is locked in by the Court of Appeals decision. Here, the Court of Appeals remand was that I failed to, and upon review of the sentencing transcript, they're absolutely right. I failed to articulate any reasons at all for the extent of the departure. So a remand was certainly appropriate. And here, the evidence does show that Mr. Mitchell did use force and the threat of force in his interference with the officers' obligations that day, including actually forcibly kicking them. So based upon that, I would score OB-19 at 15 points.
This moment is critical. What just happened here is a guideline shift that directly increases the sentencing exposure. OB-19 deals with interference with law enforcement, and by rescoring it from 10 to 15 points, the judge has now raised the advisory range. That may not sound dramatic on paper, but legally, it matters a lot. The defense objects not because the math is wrong, but because they believe this issue should have been raised the first time. The judge acknowledges that tension, even calling it a little punitive, but explains that a resentencing reopens the door. So here's the question for you. Should resentencing mean a clean slate, or should the prosecution be locked into its earlier mistakes?
From 12 to 24 to 14 to 29. Any objection to my arithmetic or range calculations from the defense on that?
No, Your Honor. I'll just, for Mr. Mitchell's benefit, I'll just note my objection to the court scoring OB-19, but I think the court has done the math correctly based on the way the court's going to score it.
Okay, thank you. That issue is preserved. Ms. Krauskopf, anything you want to say on behalf of your client?
Your Honor, the court can take post-conviction behavior into account. That is people versus Fields. And so I will note that at least from the update that we have here, he's been doing well in prison. You know, one minor misconduct for out of place is really certainly very far from the worst thing that I have seen. The report reflects that he's quiet, he's not causing anybody any problems, he's completed a program. He also informs me that he's being treated for glaucoma and severe migraines while at the prison. He was working in the kitchen, but has had to stop due to the health issues that he has been suffering. He also suffers from severe progressive degenerative disc disease, so he does have a host of health problems, but otherwise it appears that since he has been sentenced, that he has been keeping his nose clean, so to speak, in prison and doing the best he can to avail himself of programming there. I would just ask that the court consider all of that and sentence him within the appropriately scored guidelines.
This is the defense doing what defense lawyers are supposed to do, humanizing the defendant. We hear about good behavior in prison, completed programs, serious medical conditions, and a lack of major misconduct. Legally, that matters. Michigan law allows post-conviction behavior to be considered, and the court acknowledges that. But mitigation only goes so far. The unspoken tension here is this: good behavior while incarcerated is expected, not extraordinary. The real question is whether it outweighs the conduct that brought him here in the first place. Do you think rehabilitation inside prison should significantly reduce a sentence, or is the past still too heavy?
All right, thank you. Mr. Mitchell, it is not required that you would make a statement here today, and if you elect not to, I don't hold that against you in any way. You also are allowed to make any statement you wish to me today. Is there anything you wish to say, sir?
Respectfully, and I understand that there was a narrative, but there's also a police report. I got out of the vehicle on my own. There was no broken windows. Nobody broke my windows. I never kicked any officers in my truck. I got out, a dog grabbed a hold of my ankle, and it was noted in the medical report that there was 4 puncture marks on my ankle. I fell back. I grabbed a hold of the steering wheel to keep from falling, and the next thing I knew, 2 police officers had a hold of my legs. And I says, please hold on, stop. You're gonna hurt me. And they stopped. And they pulled me out of the truck. And I let go of the steering wheel and they pulled me out of the truck, and there was no fighting or nothing. I was not kicking these guys. I just fell back and I grabbed a hold of the steering wheel to keep from getting hurt. Nobody ever broke my windows. When they towed my truck, that the tow truck driver would know. There was no glass cleanup or anything like that, sir. And they walked away, and the only reason I called them officers to the truck, I just asked for their supervisor. I drove my truck 120 feet out of an intersection into a parking spot, which the police officer wrote in the statement. It said that Mr. Mitchell got aggravated because he didn't have insurance, and he asked if he could drive his truck to where he could have some light. I have glaucoma, I can't see, I'm 65% blind in this eye. So I didn't have any light, and my phone was underneath my brake pedal. So just trying to say that I was trying to be respectful. I never kicked anybody, and they never had to break any of my windows. That's obscene to me. I would never do that to officers. I would always, my whole life, try to be as respectful as possible I could ever be. And when they arrested me, I put up no fuss. When I got put on PR bond, you put me on PR bond, I had to report every day to the drug court and make myself available. Now, even though I was on probation already with Isabella, I made myself available to the court every day. And at one point I was homeless, and the VA ended up helping me get a place to live just before I got put to prison, okay? But I called the court every day and made myself available. No matter what, I would have went and got drug tested and anything else I needed to do. And my biggest thing was transportation, because my truck got repossessed after this incident. Of course, all that. So, but I turned myself in. When I come back here to court, you said I had a problem with Isabella, I didn't report, and that was my violation, is not reporting. There wasn't any criminal activity or anything like that. No drugs, no alcohol or anything like that. It's just, it was a non-reporting issue, and it was because of transportation. I don't have any family, anything per se that was helping me. But I was able to get a ride up here, and I turned myself in to you and being respectful to the court. and especially to you and everybody, because I didn't want to have any more extenuated problems than I'd already had in my life. I got divorced about 10 years ago, and my life went downhill ever since. I've tried to keep my crap together, but it's been hard. I am a veteran of the Army. I do have some PTSD, and I've had some emotional and mental issues. And I've done my darndest to try to take care of things best that I can, but I realize that I need help. And through the process of being in prison, I've gone through a really good program that's helped me that way. And I've got counseling for the PTSD. I've got counseling for being able to deal with others. And that's been my biggest problem, is expressing myself properly. And that's like before, when I was here in court, I tried to say something to you and I couldn't. I just started crying. Well, that's part of working on me. And that's what I've really been able to do since I've been here, or since this last year and a half. Now, when I was on bond, my 15-year-old daughter, I got two minor daughters, tried to kill herself. She lives in Fort Wayne, Indiana. My 13 and my 15-year-old daughters want to come and live with their father because they've been being abused and they can't seem to get away from it. And they need their father. And I've been trying really hard to keep myself together and take care of my necessary problems. Anything that I've had to take care of, I've been trying to take care of it as best I can. And I couldn't take custody of them while I was out on bond because I knew I had to come here and take care of this court. And I wasn't going to put my daughters through that more instability. So since I got put in prison, I've had no contact with them. My mother has, but they need their father. And I understand that I need to pay a debt to the state of Michigan for my actions. And that's why I'm trying to reiterate to you, I wasn't kicking anybody, and they didn't bust my windows. And I'm sorry for having to drive my truck out of a busy intersection. And I went up 200 feet and parked it. I didn't run off. I went right where I told the young lady I was going to take my pickup truck to. But to make a long story short, I'm asking for community supervision. I will do everything you need me to do. I can take a drug test today. And you know as well as I do that drugs are available, and the people that do drugs, you can get drugs when you're in prison. Don't do that crap. Okay? I'll make myself available to you any way necessary. I will too with tether. I've been successful. I was successful on an alcohol tether for Isabella County. I can pay that. I have a CDL Class A with tankers. I've been a driver for over 21 years. I've had no issues ever as a driver, ever. No tickets, nothing. I can still work. I have bad issues with my back, but I can still work. I want to pay your fines off, and I want to be able to take care of my girls.
This is one of the most emotionally charged moments in the entire hearing. The defendant directly contradicts the police narrative, denying force, denying broken windows, denying kicks. He frames himself as respectful, overwhelmed, and misunderstood. He brings up health issues, homelessness, PTSD, military service, and his daughters. But here's the courtroom reality. Sentencing is not a retrial. The judge isn't deciding what might have happened, he's weighing responsibility. And when a defendant continues to dispute core facts after pleading, judges often see that as lack of insight rather than advocacy. So what do you think? Is this a man finally being heard, or a man still refusing to accept responsibility?
Thank you.
Thank you, Mr. Richard. Ms. Goodrich, recommendations from the group.
Thank you, Your Honor. The defendant is 55 years old with 3 prior felonies and 12 prior misdemeanors. In 1991, he received his first impaired driving. In 2003, he had endangering a person while driving intoxicated. Then in 2021, he had an operating while intoxicating third in Isabella County. While he was still on probation for that OWI third, he had a failure to appear and then also incurred the OWI third here that he's been sentencing on. And then while on bond for the OWI third here, he committed a malicious destruction of personal property, it looks like, in Hillsdale County. In the PSI, I was disappointed to read that he still believes there was no reason for the police to bother him that day. He seems to lack the insight and the severity of the public safety risks of his behavior and his choices over the years. I would ask the court to uphold the previous sentence of 3 to 5 years. Thank you.
All right, thank you. Mr. Mitchell, if you please stand for the court sentence. Mr. Prosecutor noted in 1991, an impaired driving with open intoxicants in Hillsdale. He violated probation and failed to report to jail when ordered to do so. 1995, a felony larceny in Hillsdale, 3 years probation. While on that felony probation, he caught 2 additional charges, marijuana conviction and a domestic violence conviction. And then while on misdemeanor probation for one of those, he caught a couple more cases, disorderly person and a DWLS, although some of those are not serious crimes. This shows a history early on of Mr. Mitchell violating probation and committing crimes while on court supervision. Then in 2003 in Indiana, he has an OWI endangering a person and high BAC. He's given probation again. He violates probation and then does 330 days in jail. Again, showing that he doesn't comply with attempts at probationary sentencing seeking rehabilitation goals. He had a period of time with somewhat less criminal activity. In 2006, a disorderly person. In 2012, a domestic violence charge was dismissed. And in 2012, a felony non-support in Indiana, for which he was placed on 4 years probation. And some other charges were dismissed in 2012, 13, and 17. So there was a period there where there wasn't anything that would be particularly alarming to the court, a disorderly and a felony non-support. Then in 2020, he has a OWI third felony in Isabella. While he's on bond for that, he's convicted for lying to a peace officer. He gets 5 years probation for the OWI, violates the probation. And then while on probation, he catches this case, another operating while intoxicated. And then in 2023, he failed to appear for the violation for catching the new case, and a bench warrant was issued. So this case was on August 21st of 2022. Fact that just jumps out in this case is that while Mr. Mitchell is on probation for felony repeat OWI, he commits another OWI. And he drove off from that traffic stop and actively and physically resisted police officers. His version of what happened that day does not appear to be consistent with the documented events of that day. His plea resulted in a significant benefit to him. Several R&O charges, which could have resulted in discretionary consecutive sentencing, were dismissed. The habitual fourth notice was dismissed. As noted by the Court of Appeals, the guidelines could have been as high as 58 months with consecutive sentencing possible if he was convicted on the charges. And the max would be set by the court. Statutory max for HAB 4 for that would have been up to life. And then while on bond in this case, which is drunk driving while on probation for drunk driving, while he's on bond for this case, he caught a new charge for a misdemeanor malicious destruction of property in Hillsdale County. You know, most folks make it through life without that kind of 30-year track record of crimes and crimes on probation and crimes on bond. And that history supports the conclusion in the PSIR, quote, in reviewing the defendant's overall history, it is found that on multiple occasions he has been convicted of new criminal acts while under supervision and has a history of non-compliance while on supervision. So what's the defendant's response to that state of affairs? Really just to blame everybody else. He says even today that the criminal justice system, in the PSI, he says the criminal justice system has mistreated him. The police had no reason to bother him on the day of the traffic stop. He even goes so far as to say he doesn't have a substance abuse problem. Well, you're convicted 4 times of drunk driving. I don't know why you don't think that amounts to a substance abuse problem. So it shows that he still, as the PSIR indicated, quote, this defendant clearly does not take responsibility for his own actions and behavior and has no respect for the criminal justice system. His behavior in prison does not appear to be problematic. That's a mitigating factor. there's only one misconduct, which really doesn't seem like a major issue. But his recent statements during the PSI process, and frankly, even his statements today, were all, it's understandable that somebody in his situation would try to plead and bargain with the court for something lesser. But other than disputing the facts of the case, that's all he did. Dispute what happened and plead for leniency or some different treatment. Nothing in there other than saying he's got to pay a debt. Nothing in there about what he did that was wrong and remorse for it or acknowledgement that maybe part of the problem. I mean, if in several different counties and states and courts, you get all these convictions, maybe the common denominator, Mr. Mitchell, is not the criminal justice system. Maybe the common denominator is you.
This is the turning point. The judge systematically walks through nearly 30 years of criminal history, probation violations, repeat OWIs, new crimes while under supervision. And then comes the line that changes everything. Maybe the common denominator isn't the system, maybe it's you. That's not just commentary, that's a judicial conclusion. At this stage, the court isn't focused on sympathy, it's focused on risk. Public safety, repeated non-compliance, and refusal to acknowledge substance abuse all weigh heavily here. When a judge reaches this level of candor, the outcome is usually no longer in doubt.
And your behavior and how you respond in society, how you use substances and drive when you're using substances. So I think all of this shows that Mr. Mitchell still has not internalized any corrective attitudes that would show progress toward any rehabilitation or reduction of risk at reoffending. The advisory guidelines are scored at 14 to 29 months. I continue to believe that those guidelines do not adequately take into account several things: the defendant's long history of non-compliance with attempts to rehabilitate him through probationary sentences, defendant's pattern of committing new crimes while on bond or while on probation, defendant's pattern of driving while intoxicated or impaired, especially the fact that he committed a felony repeat OWI while on probation for a felony repeat OWI. I mean, I can't state more strongly that is such a compelling factor in this case. Also, the significant reduction in the dismissal of the fourth habitual and discretionary consecutive R&Os, as the Court of Appeals acknowledged, that's a valid reason, as well as the defendant's continued expressed contempt for the criminal justice system and refusal to take responsibility for his own substance abuse related criminal activity. I certainly believe that 3 years in prison, I think I stated that very awkwardly. Let me just back up. I think there's an excellent case to be made, given the history I outlined, that a truly proportionate sentence, if I had the benefit of more habituals, or any habituals, would be far greater than what I would impose today, what I'm able to impose today. And I would note, given the objections to the scoring issues, whether the guidelines were 14 to 29 months or 12 to 24 months would not change my decision that I believe a 3-year sentence is more proportionate than the upper end of either of those guidelines. And so therefore, I again commit Mr. Mitchell to the Department of Corrections for not less than 3 years nor more than 5 years, with credit for 515 days already served. There's $68 in state cost, $130 in crime victims assessment, $350 in court costs, which is well below the state court administrator's office calculation of the per case costs in the circuit, a $500 fine, and $200 OWI reimbursement. And Mr. Mitchell, you are able to file an application for leave to appeal to the Court of Appeals to challenge your to challenge the sentence here today on remand. If you wanted an attorney, I would certainly appoint one for you. You would have to make that request within 6 months. Or anything further from the people?
No, Your Honor, thank you.
Anything further from the defense?
No.
In the end, the court imposes a sentence of 3 to 5 years, an upward departure from advisory guidelines, justified by a long history of repeat offenses, probation failures, and continued denial of responsibility. Despite some mitigating factors, the judge makes clear that public safety and accountability outweigh leniency in this case. This resentencing wasn't about correcting a technical error. It became a final judgment on whether rehabilitation had truly occurred. Now we want to hear from you. Was this sentence fair, too harsh, or not enough? If you found this case as intense as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Thank you.
Okay, thank you for being here.